Hello and welcome to the 201 Clearinghouse webinar, a deep dive into new regulations. This is a follow-up webinar to the Introduction to the Clearinghouse 101 webinar that we did earlier in the month. If you're a new listener, don't worry, we review enough so that you can follow along, but feel free to go to our website at corporatemedicalservices.com, click webinar at the top right, and this will take you to the recorded version of the first webinar. Feel free to share these with anybody who needs to know. Our goal is to educate so that people don't get surprised in the next 83 days when the Clearinghouse starts. I appreciate everybody joining us today. It looks like we have a great crowd and several new attendees, and we're excited to get into this material. To help me today, I've invited Karen, our team leader in the MRO department, and I know many of you will recognize her voice. Hi, Karen.
Hey, Grady.
Hey, Karen. I know that you've been involved in this industry for a long time.
Yep, I've been with CMS. It'll be 19 years next month.
That is terrific. You must have started as a teenager.
It feels like it sometimes.
All right. So to everybody in a nutshell, what does the MRO team do?
Well, we review the chain of custody forms. We contact drivers when necessary. We report the violations to the DERs of the companies and soon to the clearinghouse.
That's great. With all these new regulations, you think it's going to get more demanding?
It's a difficult job, but I really enjoy the challenges. I feel that we make a difference into safety on the roads and the highways. That motivates me.
That's really important. It really is. Well, Karen will be joining us as we go through the information today with a few of our own questions, as well as some of those from the audience, and just to keep it exciting. So we'll jump right in. First of all, for the new people, a little bit about CMS. Obviously, we've been incorporated for 24, going on our 25th year. Our chief MRO is Dr. Joseph Sintef, who is also the chief medical director for the FMCSA. And we tell everyone that we are an MRO TPA company. For most of our clients, there is no line between the two. We just help out where we can. But for the purposes of the clearinghouse, the MRO and the TPA are separate tasks. And so we will get into that. We also manage consortiums. We have our own consortium called DotStop for smaller trucking companies. We manage other consortiums for other companies as well. We have a 24/7, 365 post-accident system where you can call, talk to a real person day or night, comprehensive sleep apnea program, and we've reported over 2 million drug screens and millions of other services in the last 25 years. Our audience is diverse, but today we're really going to be speaking to employers, safety directors, and those actually in the field that are going to be doing the work as we deep dive into how these queries and violations work. So today's agenda will be a quick review of what we've talked about, deep dive into queries, violations, then we'll touch base on corrections and enforcement. At the end of today's webinar, all employees are welcome to receive any of these documents or all of them. You just have to email ch@corporatemedicalservices.com, and we'll show that email again at the end of the webinar. Pay attention to the last one. We are more than happy to send PDF slides of this presentation. That way, you don't have to spend all your time trying to take notes and keep up. Just allow the information to sink in, and we'll send all the writing material to you later on. So quick review of the clearinghouse. The purpose of the FMCSA Clearinghouse is to store violations and respond to queries with any stored information. That's basically what it is. Registration is open now for drivers, carriers, MROs, TPAs, SAPs, and I think that's it. The query plans, which you can purchase, are supposed to be available in the coming month in November, and it is anticipated to go live January 6th, 2020, except for state driver license agencies. We're moving into queries. The full query is a new term that will be required for any pre-employment or when a limited query shows information. The important special part about a full query is that the employee must give specific consent by actually logging into the clearinghouse. On the other hand, a limited query can be used for verifications. There is an annual requirement, and that limited query can be used as can be performed as long as you have a blanket consent form, which is provided by your company.
Hey, Grady.
Yeah.
We've had a lot of people asking for a template for that limited query.
And that is great. I don't know if you noticed, but that is one of the available downloads that we will have for people after the end of the webinar. And just so happens that our next slide after this gets into that a little bit deeper. So when you start any query, this is not the actual form, but I was lucky enough at the ATA last week to sit down with the FMCSA, who allowed me to watch as they logged into the beta version of the Clearinghouse website. And I have to admit, That made me change my hashtag from last webinar from "it doesn't exist yet" to "it really does exist," because they showed me it actually is out there. There are a few bugs left, but it's out and it's working. The first step to querying or violations is an employee validation. You have to enter in all of this information: the driver's first name, middle name if appropriate, last name, driver's license state, number, and date of birth. Once you enter this information in, you have to try to validate it. For a query, once you click validate, it first looks into their system, into the clearinghouse system, and if nothing exists, it then goes out to the CDLIS, which is the Commercial Driver's License Information System, to look at all the states to verify if it matches a record out there. For a query, it has to match or you get stuck. It will not let you go any further. We'll get into that a little bit later. For violations, it will allow you to go on past it. Now, one other thing about the Clearinghouse website, in several places you will notice a small I with a circle around it, which is the same symbol that CMS uses on our web portal, just to give you more information. As you go through the different fields, there are several locations where that is available to give you more information. Like I said, it's the first step on violation reporting. When you are doing the queries, you cannot override that, but when you're doing a violation, it will allow you to override and report on a driver even if it does not have a match in the clearinghouse. That is definitely something we're going to have to pay attention to see if it causes issues as time goes on. Okay, so deeper into queries. When you hire drivers, you have to do a full query. You cannot do a limited query for a pre-employment. So here's what we're thinking. In 2020, very few drivers will be registered. It would be smart to do the pre-employment queries at orientation. If you try to do this before they come into orientation, it's going to be challenging. You're going to have to make sure that your recruiters and your safety are working together to follow the process. So if you follow what we're thinking, at orientation, you show the drivers how to register in the clearinghouse. They may come in and say they're already registered. If not, you can show them how to log in. Once they show you that they have a clearinghouse address, you then put in a request for a full query, and you have to choose the pre-employment option. We'll explain why that is in a little bit. If the driver is not yet registered in the clearinghouse, then it will send a piece of paper to their CDL address location. If they are listed in the clearinghouse, then it will send them an email and give them instant notification.
How do you know how does the employer know if the driver is already registered or not?
Well, the clearinghouse will not tell you. You have to ask the driver. There's no way to tell in the actual clearinghouse. That's one of the reasons we are suggesting that you do it at orientation, where you can either look over the driver's shoulder or at least talk them through the process, because you don't want to have them send out a notice. Also, once you do a full query, the FMCSA only sends one notice. Now, ideally, once the driver logs in, even if a piece of paper has been mailed, they'll be able to give you consent, but then there's a piece of paper that might show up at their house a week to a month later, and it's just going to do nothing but cause confusion. That's why we think it's important to have them log in first. So once you request the full query, that's when it shows up on their account, and you can easily show them how to give consent. It should be a simple green or red button. Once you go through that process, you should also have them sign the limited query consent form that we talked about a minute ago, the template that you should have in your system. We think that it's a great idea to start as soon as possible, even now, to have drivers signing these limited query consent forms so that you have a significant amount of your employees that are already given consent by the time the clearinghouse opens, and certainly by the time that you decide to do your annual verifications next year. The last step is to grab the report that the clearinghouse sends you, whatever that's going to look like, and make sure you file both the query and the response that you get back for the next 3 years. Now, that's in the regulations. We don't know what or how you're going to be able to print off the query request or the report that you get back, but there should be an easy way once we get going to understand that. It's important that you save those for 3 years. The wording on the regulations say that an employer who maintains a valid registration until January 2023, I think it is fulfilling this requirement, but it's pretty clear that you have to have something saved for until that time. So we've talked about the pre-employment query. That ends that workflow. So there is a requirement for an annual query workflow. We struggle with the word annual because you're allowed to do the query more often than you want to. Now, there's no set time to do this annual query, but you have to do it at some point during the year.
Grady, I've talked to several carriers and they plan on verifying their drivers every time they do a random selection.
Yeah, that's something. You have to keep in mind there is a cost involved. At this time it's $1.25 per query, but there's a good reason to do your queries more often than just annually. We'll get into that in the enforcement section. So you can do them as often as you like. You do have to address how frequently you plan to do it in that blanket consent form that we've talked about, and we've already said that we expect it would be a great idea to start now with that consent form at orientation. And I think, and we've already said you have to, okay, so not only do you have to keep the query form for 3 years, you have to keep a copy of this blanket consent form for 3 years after employment ends. So if you keep this driver for 90 days, it's 3 years and 90 days. You can all do that math. You keep them for 10 years, it's 13 years. Good question that has come up in the past is why would you run a limited query instead of just going ahead and doing full queries for everybody? And the reason for that is when you do a full query, as we talked about in the pre-employment section, the driver has to log into the clearinghouse and click the allow button. And I think that when you're trying to do that with your entire fleet, it would be very cumbersome to try to do full queries for everyone. All right, so we talked about the query template that Karen said that a lot of employers are asking for. We put a copy of it up here. And again, we'll have it for send by email or download later on. You'll notice the highlighted portion is saying that employers may wish to include the terms of the consent. This is what we're suggesting. The phrase employer may verify at any time during my employment without limitation on the number of verifications. Now, obviously, you're going to want to run this through your legal department, but what this does is allows you to change your query frequency however you wish without having to worry about getting your drivers to sign a whole new set of limited queries. And this allows you to do it theoretically once a day. If the price comes down, it's a terrific idea to do it that way. Or if that's something that's important to you, there's also an unlimited query option. It's a little expensive. We'll talk about that. I think we touched on it on the 101 webinar a couple of weeks ago, but it's a possibility if you wanted to go down that route. Okay, so we've talked about pre-employment. We've talked about the verification. We've looked at the annual template. That's everything that goes right. Let's talk about some what ifs. So let's imagine that you do a full query and it shows a violation. What do you do? Well, the first thing to keep in mind is that the violations, even if they're already cleared up, will still show for 5 years. So pay attention to what it's showing you. Again, the website, although it exists, we haven't been able to see the full details. So don't know if it's going to be a green light. Don't know if it's just going to list that violation and you have to study it. But it might be that they have had a violation, performed all the necessary steps, and they are good to go. It will continue to show up for a total of 5 years from the date of the violation. That's when you would default to your company policy on previous violations. Might be a good time to look. I know that a lot of companies have a zero tolerance policy. However, as we go on, a lot of these are going to start to show up that we haven't seen before, especially since we're just checking 3 years in the past. But simply put, if there's a violation that shows, don't put them on safety sensitive duties as long as they have an open violation. You can go back to them and tell them to take the steps that we will talk about shortly. All right, so what if a driver says they're registered, but the query just doesn't run? That's just a problem solving exercise. That means either they've not registered with their correct CDL or they didn't give consent. Maybe they thought they did. This is going to be a great opportunity to have them at orientation to be able to walk through the steps with them just to make sure that everything matches, and it should be able to green light it. You don't want to waste a whole lot of effort getting a driver to the game and have this be the problem. So the next question would be, what happens if the driver just outrightly declines consent? Well, again, don't assign them to safety sensitive duties. That part is pretty simple. If you don't have a green light from the query, you don't put them to work. Interestingly enough, we learned this, you're not charged for a declined consent. So if you send anybody a consent form, they say no, you don't get any charge at all. It's only for completed queries. If the person accidentally hits mistake, I know I've done that 10,000 times on credit card machines and decline accidentally, you can simply request a new query. Again, really easy to do if they are in front of you and can walk through that process. A couple more. So let's say that our driver took a drug test and was reported positive after your full query. Say they were going down the road and applied at 3 or 4 different places, took 2 or 3 drug tests. They knew they weren't going to be negative until they got to your company, and lo and behold, they passed. This is where, when you check that pre-employment box on the query, when you do a full query and you check pre-employment, you get a 30-day update period where any and all violations are reported to all companies that did that full query. That is, we're going to see how well that works. There's a lot of discussion about if that's going to actually be a functional system, but we hope that works very well. It's a great concept because we know that this is the biggest loophole, is drivers that bounce from one company to the next. All right, so what if a limited query shows information? And what this means is that when you do your annual or your regular verification query, it pops back and says there's something going on with this.
What happens if the driver is unavailable to give consent for a full query?
Oh, that's a good one. So a limited query automatically turns into a full query, and it goes to the driver. So let's say that they're on vacation when you happen to be doing this. I think that's what you're asking. And that was a recent question. The driver, as long as they are not assigned to safety sensitive duty, is not breaking any rules. So what you do is you set them off duty. When they return to come back to work, you have them consent to the full query. It will sit out there until they give consent. Now, if they happen to be reachable out on the beach or wherever, you can always try to contact them, have them give consent, and get it cleared up while they're away. But as long as you don't put them to safety sensitive duty until you get that green light from the full query, you're perfectly fine. Also interesting, the limited query, when it automatically turns into the full query, they only charge you one time, so it's not a double dipping. If the driver does not give consent within those 24 hours, you do have to remove them from safety sensitive, like we said, until they come back to duty, or forever if they don't ever give consent.
Why not do a push system like California does?
Oh, push system like California does. Man, why didn't you write the rules? No, that was actually also a great question, and that was one of the few where the very informed and knowledgeable ladies from the FMCSA had to default back to, this is how they wrote the rules. It sure would make a whole lot more sense, instead of us having to do a limited query every year, every 6 months, every 3 months, if instead the government could just push any violation information instantly to us. Definitely a rewrite would take advantage of that, and I'm sure if you and I got a chance to write it, we'd make all new mistakes. So just to cover up queries, just a few quick helpful hints. Some of these we've talked about and some are new. If you ask for a query, it should be almost instant after the driver gives consent. There should not be more than an email delay, maybe 4 or 5 minutes. So if you ask the driver for consent, they are registered in the program, and they either don't give consent or you don't see anything back, they do get an email. So if you don't get consent pretty quickly, you can just cancel your order and resend the query. It'll give them a new email if they are registered, or send them a new piece of paper. And there's no charge unless it's a completed query. Only the pre-employment query gets that 30-day update that we talked about. So if you don't check that box, then it just gives you whatever information is in the database. We already said a limited query shows data automatically, gets converted to full query, and there's only one charge.
Don't forget that queries are $1.25, whether it's limited or full.
Yep, for now. There is certainly not a regulation saying that they're going to be $1.25 forever. The Clearinghouse regulation says that they can collect a reasonable fee, and the only exception is that a driver accessing their information has to be free. So as that goes on, we don't know. Now, you can always buy the unlimited plan for a simple $24,500. That works out to, if you want to do over 19,600 queries a year. I know that we have a couple of people listening in that probably are doing that, but for some of the others, that's not really a realistic option, and we've all scratched our heads as to how they came up with that particular break even. For anything else, it's a simple $1.25 per query, at least for now. Might be a good idea, though, to pre-purchase some if you think that price is going to go up. We don't know what kind of information we're going to get from the clearinghouse when they start to increase that or decrease that. All right. Query packages do have to be pre-purchased. They're not pay as you go. You don't pay a balance at the end of the month. You have to purchase X number of them. And so we understand that credit cards, PayPal's bank drafts will be accepted. If you do that unlimited plan, I think they said that the bank draft is the only thing they will accept. They're not going to allow you to put $24,000 on your credit card. The clearinghouse is supposed to send you some kind of warning when your balance is low. They don't really have that figured out. If you buy, I think they said 10%. If you buy, say, 200, then it would send you that warning at 20 or so, something like that. They don't really know. One important thing, though, is the TPA cannot purchase a plan for you. The employer has to actually purchase that plan as their login. And that's about all there is to queries. Maybe I can't do a Tom Hanks. Can you do a Tom Hanks impersonation?
I don't think I want to try,
Okay,
but
good.
we have had a couple questions come in, Grady, if
Okay.
we want to touch on these.
Yeah.
Somebody has asked, has anyone had any success in registration?
Yes. Yeah. We've had a lot of clients that have signed us up to be their TPA. We've had a bunch of clients that have signed up that we've never heard of. And so we are reaching out to them to see if they need to sign up with us. I know that some of the clients have told us that there are not a lot of options for TPAs that are currently registered out there. And so we believe that we are definitely working ahead of the curve on this, and that our clients are going to be informed, and as well as all of their friends that have anything interesting. I've heard a couple of people that have had issues with registration, but if you go through the process, put in your email address and a secondary contact, it's really pretty straightforward. One thing that, going back to the forms that we have available, the FMCSA has created both an employer aid and a driver aid, which is a step-by-step of how to register. Those could come in useful if you haven't registered yet, if you're concerned about the steps to get there.
This is a really good question. Would there be any problem with running an annual query to coincide with driver annual review?
No, that'd be a great idea. I know you said that a lot of people you've talked to are going to do it during random selection periods. I know a lot of others are talking about doing it during the MVR period. Anything that you want to do to simplify your process. And then again, for 2020, we certainly don't expect there to be anybody with a violation January 6th. There'll be a lot more in December. So if you wanted to wait till December 1st, do your entire fleet, I think that meets the bill. If you want to do them all on January 6th and expect to get nothing back, that may be the easier path, but maybe not the more responsible path. So taking that, we're going to move into violations. And I think we're still okay on time, but I'm going to try to push through to make any time for questions that we have as we go on. So violations in the clearinghouse are going to be reported by the MRO and the employer or the TPA on their behalf. So the employer or TPA is going to report all alcohol positive. It's important to know that alcohol does not go through the MRO. Now, if you have a TPA, and we have a lot of our clients on the phone that use our TPA service, some that just use us for an MRO, and we have a lot of others actually that are not our clients at all that we just hope that we're able to work with. So keep in mind, alcohol positives go to the DER, and that's it. If your TPA is involved with your ordering process, paying your bills, we will also know about it, but it's the DER's responsibility to make sure that those get done. Employer will also send reports for actual knowledge, and if you are in the business of putting people back to work after positive tests, you are responsible for negative return to duty tests and completion of follow-up testing reports. The MRO will report drug screen positives, and some types of refusals. SAPs, or substance abuse providers, report treatment of driver, basically. And those are the three people that will be submitting violations to the clearinghouse. Okay, we're doing this is pretty intense stuff that we're going to get into with the employer. Don't worry about writing all this down. Please let us know for the steps. You can also go to the regulations in 382. I think they start in 0.701. That we can go through what you have to report and how you report it. But we're going to touch base on all of this just so that you know. So an employer will report all positive confirmation tests of 0.04 or higher.
What about BATs under 0.04?
So a 0.04 or higher is a DOT violation. If it's from 0.02 to say 0.039, that requires you to put the driver out of safety sensitive duties for 24 hours, but it's not technically a violation. Anything 0.02 or less is not considered a non-negative result, so it's considered a negative. And most alcometers should be reporting a negative for anything that's less than a 0.02. So you will also, like we said, report negative return to duty tests, actual knowledge, report that all follow-ups are completed, and all alcohol refusals. Here's where it gets interesting. Some drug screen refusals. Get ready. These are the refusals that the employer has to report. Now, this really hasn't changed. As a matter of fact, it's gotten a little bit less than what the existing regulations do because a couple of these refusals have been moved to the MRO. But it's important to see all of these because I know that this is not done as widely as it should. We know we see reports from time to time of clinics that allow a driver to come back the next day for a test or leave to go get their children or not do an observed test and just walk out. Then they want to go take a second test the day after, or they get caught wearing a prosthetic device and are allowed to continue the test. All of these things are refusals. The DOT standards are set for safety being number one. And so any of these things are considered refusal and reportable to the clearinghouse by the employer or the TPA. And whether we are your TPA or not, if you want help getting into these, especially as we get started, call us and let us know. Tell us what's going on and we'll help walk you through these as we go on. Do want to point out the very last one that we've got underlined. One of the refusals that is currently on the books is if you admit to the collector or MRO that a donor adulterated or substituted the specimen. That has been limited to the collector only. So if a collector calls you and says, this young lady just told me that she substituted the specimen, she's caught, she admitted it red-handed, you report that as a refusal. However, the MRO will report something that we nickname the shy bladder refusal. And the shy bladder refusal is what happens if a donor stays the full 3 hours but can't provide a specimen. Now, today, that is fully in the responsibility of the DER to report. You report it to you terminate the person, put it on their driving record, and that follows them where they go if it's not a pre-employment test. But starting January 6th, it's the MRO's job. This is going to be complicated. The reason there's going to be complicated is there's no specimen. MROs are looking for specimen reports for the lab. We get lots of chain of custodies. Lots of chain of custodies that don't even belong to us. Lots of chain of custodies that never got sent in. And most MROs are not actively pursuing all of those that don't have a specimen that comes in. It's entirely possible that they will miss a chain of custody that just has a note in it, something about donor stayed full time and no specimen provided, because a lot of collectors will not make an excellent note on that. A lot of MROs are going to miss it. So keep in mind the way that the regulation says is that if your driver stays the full 3 hours and leaves, it's the DER's responsibility to work with the MRO to inform the driver that they have 5 days to go see a medical provider, which could be the MRO or another qualified physician. It's not typically going to be their family doctor. Well, it could be their family doctor, but they have to provide a good medical reason, which is acceptable to the MRO. And by the way, Karen, pop quiz, which two things are not acceptable reasons?
Social or situational anxiety, shy bladder, dehydration.
That's what it is. Yeah.
Knew I knew it.
So these are things that we get very often from people that are saying, I couldn't go. I was just nervous. I couldn't use the restroom. Those are not acceptable reasons. And those would be detailed as a refusal. So January 6th going on, that's going to be in the MRO's purview. Please, DERs out there, work with the MRO. Make sure you have a good line of communication where you know that this gets reported, working with your TPA as well, because they should have some information on this. We don't want to let these get through the cracks. So continuing on, back to the employer, the other information. So what is going to be required on the clearinghouse? The first thing that they're going to ask you, remember that driver validation form. Almost everything you do, whether it be a query or a violation, is going to start with that validation form. You have to enter in everything just like it shows on their CDL license. And like we said, for a query, you have to get everything correct. On the violation, it lets you override it, but don't do that. That means that you haven't typed in something right. If they have a valid CDL, you want it to match up so that that violation gets stuck on their CDL. The other information that you have to provide is the reason for the test. This one seems like it would be an easy one. Since you are the employer, you have to list the employer's name, the address, and USDOT number. This will probably be pre-populated on the web portal. The date of the test, the date it was reported, and the test result. Now, documentation. when you report refusals, you have to list documentation. You have to include the date or time when they were notified to appear at the testing site, particularly for what they call an A1 refusal, which is when the donor did not show up for any test except a pre-employment. So if you say John was sent for a random and he didn't show up, you have to be able to list some type of documentation to prove that. You're also supposed to list the date that they were terminated, resigned, if applicable. And this is one it may apply to some of you out there. We have another series of webinars coming up for our small companies and consortium members, but it could apply to a very large carrier. If the employer or the owner is listed as a driver, as an active driver, you have to have proof that the CPA was designated as their service agent. And this really boils down to, you can't be trusted to report yourself if it's a violation. So you have to assign a TPA. If you own the company, you have to have a TPA assigned to do that for you. You also have to have proof that the employee was given all this information. So on the Clearinghouse, the web portal that they showed me, this is the demo version, there's just a simple checkbox that says the employee was notified. Check yes or no. You have up to 50 megabytes. Don't know why, but that's what it is, allowed per violation to put this documentation in. There's actually a phrase, I think it can be, just documents, PDFs, audio recordings, video recordings, basically anything you have to prove your case that goes in there. So it's pretty interesting. Can't wait to see how it works. Continuing on. Now, actual knowledge is something that the employer will report. After talking to several clients lately, actual knowledge is something that just really isn't done that much. Karen, do you remember seeing anybody that's reported any actual knowledge or any questions on that lately?
Not that I'm really aware of.
Okay. So we looked it up. We wanted to get the absolute accurate definition. So the actual knowledge is direct observation of an employee using alcohol or controlled substances. This is not reasonable suspicion, not where they look off, smell, acting funny, strange behaviors, all of the reasonable suspicion testing. This is if you see them using drugs or alcohol during their safety sensitivities or controlled substances at all. Interestingly, the definition also includes information provided by the driver's previous employers. Not really sure how that one works. But the one that's most common for actual knowledge is a traffic citation for somebody under the influence. If you are aware that they were given a citation, even if it was not a DOT reportable test, post-accident, if they were given a citation, you basically file this violation as actual knowledge and terminate them based on that. The other one is if the employee comes to you and in an admission that they have a problem, except for 382.121.
What is 382.121?
That's where if a person comes to you and they're not scheduled for a random test, they're not trying to get out of anything, they just come to you and say there's a problem, there's a specific set of instructions of how you deal with that, basically to allow them to seek treatment without going through a violation. But that doesn't count if they're selected for a random and they come to you and said, hey, I have a problem before their random test. That would be filed under actual knowledge and employee admission. So pretty much the same stuff that's required for actual knowledge. You don't have the specimen ID, but you do follow that same driver verification. You do have the employer's name, which is you, the date, witnesses if you have any, and their contact information. That's an interesting, and a description of the violation. You have that same 50 megabytes to upload. Here's the description that's on the Clearinghouse portal: affidavits, photographs, video, audio, employee statements, or other admissions. This is where you build your case. You also have to prove that the driver was prevented with all of this information.
Grady, how soon after a violation occurs does it have to be reported?
I'm getting to that. Hang on just a second. We do have to go over, this is at the end of the violations for employers. An employer who's also a driver, which is what we talked about. Commonly, you'll hear people say owner-operators. But an owner-operator is typically a one-truck fleet. So the way the regulations are written is if you own some or all of the company and you are also listed as a driver, you have to designate the TPA. So that's going to be really interesting to drivers or to fleets of all sizes. The MRO, just to close up how violations are reported. So the MRO obviously is all by themselves to report positive, adulterated, or substituted drug tests. This is not something that you pick in the clearinghouse. When you do a drug test, the chain of custody that's used is going to list an MRO. That MRO is responsible for getting this done. Now, as we said, we know that a lot of MROs are going to miss that shy bladder. We also believe that there are a lot of MROs out there that are not going to be trained in the clearinghouse because MRO can be used for federal, but it's also a non-federal term. I am not aware of any intense educational drives that have gone on to different MROs. So if you're using a small clinic that has an MRO that's maybe not a large volume DOT MRO, or honestly, even some larger MROs may not know that this is going to be required January 6th. Please contact them. Reach out to the MRO if you're not using CMS, or if you are using CMS, I'll tell you right now, we are ready to go. But if you are using somebody else, make sure that they're going to be doing this on your behalf. It's not something that you're responsible for, but it's certainly something that is part of a good compliant program. Again, the shy bladder refusals, the MRO has to have almost the same information. We start with that same driver name, date of birth, CDL and state of issuance, test reason, specimen ID number, date of test, all that same stuff. All right, Karen, I'm getting to your question. Sorry, you had to wait a couple of slides to get there. So what's the typical workflow of violation? So you're going to get notification, whether it's a positive BAT, maybe a refusal of some type, or actual knowledge. First thing, take the driver out of safety sensitive duties. Don't do the clearinghouse first. Get them off the road. Collect your documentation, which is going to be that up to 50 megs, any kind of documentation, any kind of recordings, anything that you have to prove that. Now, the positive BAT is not going to require much, but the refusal and that actual knowledge, you want to build your case a little bit there. And then you have up to 3 days to report to the clearinghouse. So there you go. It's whoever wrote these regulations, we think there was a separate group that was writing each one, because the employers have 3 days. The MRO has 2 days. The substance abuse provider has till the end of the business days. So it's maybe it's a 3, 2, 1 countdown. I don't know. It sounds good. So the violation then will stay on the clearinghouse for a minimum of 5 years, even if they immediately go and resolve it with a return to duty workflow.
CCS required election sites.
The violation will stay in the clearinghouse forever if they don't complete the return to duty process. Now, there's been a lot of confusion with that. So if a driver takes a positive test, or takes test is reported positive, refusal, et cetera, and they say, you know what, I'm just not going to be a driver anymore, and they go on to a different industry, and then 10 years later they decide that they want to go be a driver again, it's still going to be there waiting on them. So this is, if it works well, and we always still have to say with this, if it works well, because it is a government program, it will be a great improvement on what we do have. If they do have it positive, get it resolved, after 5 years, it will disappear. And so you don't have to show that on any queries. So we've talked about the violation workflow, and we've talked about if you're allowing driver back. So Karen, kind of run us through how somebody after a violation would get back to work.
Sure. To go through the return to duty process, when the employee has failed the drug screen, then they're notified of the violation. The employer then would provide a list of substance abuse professionals to that employee's area.
And if they don't have that, we can help them, right?
Correct.
Okay.
Yeah,
good.
there are several websites that are available to help with that area.
Good deal.
The employee then would choose an SAP, and that's, based on their personal inquiry to it, to find one that's close to their location, what works with their schedule, and time and money cost on that. The SAP, this is something new, would then upload that initial assessment once the employee's gone to the clearinghouse website. The employee would then continue the return to duty training. The SAP then would also upload the completion notice to the clearinghouse website and provide their treatment plan to their employer. The employer would perform and continue the return to duty, or perform a return to duty test, which would be obviously observed. Once that return to duty test comes back, then the employer would then upload that negative result, assuming it is negative, to the clearinghouse.
The TPA can do that as well, but not the MRO.
Correct.
That's an interesting. The MRO does not report the negative test results. They only report positive drug screen test results. It's kind of weird, but that's the way it is.
Once that negative test result has been completed, then the employee can return to safety sensitive duties. The employer sends the employee for follow-up testing as per the SAP's plan. which has to be a minimum of so many per in a certain time frame. The employer
Yeah,
would then.
I know a lot of SAPs are doing a 5-year plan now for different violations where the employer will have to send them for essentially unannounced follow-up testing for up to 5 years and a good number, 20, 30, 40 tests.
Correct. And those all have to be done observed. The employer would then upload the completion report to the clearinghouse once all those follow-up tests have been completed.
So to be clear, the employer doesn't have to upload every single follow-up test, just the completion.
Just the completed, once it's been completed after the SAP plan is complete. And that violation will stay on the clearinghouse for 5 years from the date of the violation.
So if the driver, after 4 years, decides he's going to go or she's going to go back into truck driving and to get that resolved, and it takes them about a year to do that, it would almost immediately disappear after they got resolved. But if somebody went into it after 6 months, it would stay for about 5 years after it got resolved. That may have been confusing. Just say yes.
Correct, Grady.
All right, so a couple of what ifs on violations. Let's say that the driver does complete his return to duty test and it's a negative, which means that the driver can go back to safety sensitive duties, but they don't do all of those follow. Say they're for 5 years and they leave that one employer after a couple of years. Well, let's see if Grady can hit the right buttons. All right, so there we go. So those regulations haven't changed. The new employer, if they go to a new employer, has to get the treatment plan from the SAP and or the previous employer with all of the follow-up testing. Now, I don't know if that's ever a real problem for anybody or not, but if you are the new employer, then you will see something. If it's been a couple of years, let's say that a driver starts that return to duty and then maybe they don't go through with it, and then a couple of years later, that's something that could have been missed easily before when people are doing their drug and alcohol evaluations. It will show as an open violation until that completion of follow-up testing is filled out by an employer. So the process has really improved on that because they'll be able to see that for a long period of time.
How will an employer know if an employee has finished up the follow-up tests?
It's going to be kind of a hidden information, not hidden. You're going to open up the clearinghouse and it should show you that they are allowed to be in safety sensitive, but not yet complete. So you'll know at that time that you could not put that person back to work without getting SAP information and the follow-up plan.
Grady, we had a question come in of how does the employee complete an SAP program if he's no longer employed?
You don't. You have to be doing safety sensitive duties to continue on that SAP program. And so if they're doing their follow-up testing, then they are progressing down that road. But you have to, in order to finish the SAP plan, you have to complete X number of tests as you work. And so if you stop working, that program essentially goes on pause. And if you're gone for more than a 2 or 3 year period of time, it probably needs to be reevaluated by the SAP to see if that needs to be included. That's certainly a complicated question, and I think that will be a case by case. So whoever sent that question in, I don't get to see who that is yet. We'll certainly follow up with you and like to talk about that further. All right, so what happens if the driver gets a new CDL in another state? The clearinghouse assures us that multiple CDLs and license permits, CLPs, will be linked in the back end using that commercial driver's license information system. That system is supposedly out there and ensures that people do not have multiple licenses in multiple states. So the employer will only see the current CDL, but all the violations will show. You will run into something at some point where a driver is going to give you a license in one state and they have a newer license in another state. That's one question that we've heard, and the clearinghouse says that CDL will simply not verify. So that will be a situation, if you know that you put in all the information on the driver's license, it may be a great time to go to that driver and ask them if they have a different driver's license and see what their response is. All right, guys, that's it. We're done with violations. We're getting close. So moving on into corrections, actually, I think we did have another question that we want to look at. So clinics sometimes report a person did not show up for a BAT, but they get results before they did. How long before you report a no-show, or in that case, a refusal? According to the regulations, you have up to 3 business days. I think that would be a situation where your documentation would really help you. Getting getting something other than a verbal. And I know that that's something that we at CMS do for our clients is anytime someone is scheduled to go to a location, we follow up personally. We have staff that that's all they do is call clinics to follow up on that information. And we're often told from a clinic perspective that the driver did not show up for testing, only to find out, like this person did, that a day later we get a result from them that they actually did do testing. So I think what we are going to push further is to get that in writing from the person. And that's actually the section that we're getting to is in corrections. Now, I don't remember that the employer has a specific time frame to do corrections, but the MRO does, and we'll talk about it in just a second. So corrections, where we're starting is what can a driver challenge? So let's say that we know this is going to happen. A driver, especially if somebody does that override validation issue, a driver at some point is going to get an erroneous report put on their record, or they may just want to challenge it. So it's important to know that in the rules, they can challenge the accuracy of the information, such as, was this really me? Did I really take a test in New York? But they cannot question the accuracy of drug test results or refusals. Now, this seems to kind of conflict with that idea of getting all the documentation for a refusal together, because if a driver can't argue with it, then what's the point of doing the documentation? But I'm sure that that will quickly either be changed or addressed, because if in fact a driver did not refuse and can prove that they did not refuse, they certainly should be able to overturn that on the clearinghouse. A driver can also request actual knowledge be removed if the DUI does not result in a conviction. And that's a good thing. I think that's the same as the actual knowledge regulations already are, is that it comes off their record. Obviously, if as soon as they receive the citation, you can file the actual knowledge. But if it ends up not being a conviction, they can request that it be removed. Now, whether the employer removes that or whether that has to be done by the system, that's another question that we will have to find out as we go. The actual knowledge, if you don't meet those criteria on the failure to appear for a drug test for the refusal or actual knowledge, they can also request that. So the drivers will use the data queue system to remove erroneous information, to request that it be removed. I think this is something that drivers are going to have a steep learning curve. I know that we've talked to a lot of employers who use the data queue system and are not really impressed with the speed or efficiency or how easily it's used, or sometimes the response. Our understanding is that when the driver logs into the clearinghouse, they will not be able to directly challenge a result. However, it will give them a link to the data queue system where they can log in and challenge the result there. I believe I put it, yeah, the FMCSA says that they'll respond within 45 days. If if a driver can show or request that an expedited, I don't know what an expedited is, but an expedited request can get a 14-day result if they're approved, and basically they have to say, this is affecting my ability to work. So I would think that a lot of people would file expedited requests. If the driver disagrees with the expedited or the standard request, they do have the ability to request an administrative review, and the FMCSA will update anybody with a correction if one is made that originally received any info that was later determined to be wrong. So those are corrections. I think there's one more on the next page. So this is where we're talking about if an MRO submits a violation and later changes the result, the clearinghouse would have to be updated within 1 business day of the refusal. So Karen, why would an MRO change a result?
That would be a good question, Grady. If an employer requests a file to be reopened due to information not available during the MRO interview, we could overturn a result that was previously reported to the DER based on that new information.
Great. So yeah, it happens not very often. I know that we request that request come from the employer so that they are on the same page as us, because we would never want to result a positive or refusal request to an employer and then change it without their knowledge. So we like to everybody be in the information when we do that. That's not a DOT reg, that's just something that Corporate Medical Services does. Okay, let's see, moving on. Let's stop here for just a second. I think we have had a couple of really good questions come in. So what happens if an employer gets a CDL license while they're employed with you? So that's going to be just new information. They will, and we'd have to look into that. Now, if they get a CDL license, typically they're going to have a learner's permit first. They're going to take that initial pre-employment drug screen with their learner's permit, at which time you could do a full query. Now, even if once you have that commercial learner's permit, then you should be able to register in the clearinghouse, provide that full query information, which will get you in the door of doing that work. And I'm sure that those regulations are already established. It's been a long time since I've looked at those, but I would think that that's the way. It's from a learner's permit up. Once they move up to a CDL and they move into different organizations, you can do a full query once they have that number. I know that the CLPs and the CDLs are supposed to be tied together. Well, with a lot of acronyms, the CDL, CLP on the CDLIS system. Another question, somebody's asked, do we need 2 accounts if we have 2 DOT numbers? The answer to that is yes. I'll add to that, there are a lot of companies, particularly intrastate companies, that don't even have a DOT number. You are required to register with the clearinghouse for each different DOT number, and any company that requires safety sensitive, FMCSA duties. We're talking to a lot of people here that do different modes too. So let's take just a second. FMCSA is motor carriers. So there are other modes of transportation, railroad, federal transit, which is public busing, air aviation.
Coast Guard.
None of those right now, Coast Guard, none of those are currently subject to the clearinghouse. It's only motor carriers. So that is something. So if you have a DOT number that one might be for FMCSA, another for FTA, only your FMCSA is going to require that. But we also have a lot of carriers that have multiple DOT numbers, and so you would need to create a different account for each one of those. Karen, have you got one?
Yeah, this one I actually can answer. Question is the employer required to give the employee SAP info if their company policy says they lose their job upon any positives? And yes, it is a DOT federal regulation that states that the employer is required to provide a list of SAPs available to the employee. Now, we do have links on our website of some websites that make it a little bit easier for the employers, or Google substance abuse programs and find, different substance abuse professionals in the employees' areas. Another way to get them, but it is a DOT regulation that they do have to provide that to the employee. And then second part of that question says, can they dismiss the driver without getting them into an SAP? You don't necessarily have to get them into an SAP. You just have to provide that list to them.
Yeah, that's totally up to your company policy. If you want to assist with that return to duty or not, your only obligation is to give them a list of substance abuse professionals. And if you decide to employ someone who, after having a violation, that also is your company policy. Like I said, we have a lot of companies that are zero tolerance. We've got a lot of companies that do put people back to work. I think it's not out of question to say in our current marijuana environment that we'll have a lot of return to duties for marijuana, more than we've had in the past, especially as tight as the driver market gets from time to time. Taking one other thing into account, that the American Trucking Associations, the ATA, has put out a very strong policy that they are going to be working against any marijuana legalization in the federal government realm, which, as most of you know, it's already there. We have no current indications that marijuana will ever be allowed for a motor carrier on that federal test panel. Okay, so we have also had a couple of questions that are outside the scope of this webinar, and we can reach out to you individually on that. And unfortunately, I think we're getting close to time, so we're not going to have a lot of questions. We'll have to leave some unanswered, but we will reach out. So enforcement, as of 4/20 of 2020, next year, the CVSA, Commercial Vehicle Safety Administration, or basically any commercial vehicle law enforcement, will be able to check the clearinghouse at roadside inspections using that CDLIS system. And there will be an out-of-service code for any outstanding violations. Karen, we talked about this. This is why you might want to do that limited query more than once a year, because if your driver's at a roadside inspection, the law enforcement finds out that they do have a outstanding violation, they're going to put them out of service, and that will affect your CSA score. Now, we don't know who came up with the date of 4/20 of 2020. We don't know if that is just random or if that is a tongue-in-cheek reference, but we'll just take that as it is. Also, enforcement. We talked about the one thing that's been delayed for 3 years is the state driver's license agencies will use the clearinghouse to verify new and renewal CDLs. So I have to give a guy named Bob Weeks credit for this. And those of you in the Minnesota area probably know Bob, and you can give him a pat on the back. The reason for this 3-year delay is that when they wrote the final rule for this clearinghouse, they anticipated that driver's license agencies would use the clearinghouse to see if someone had a violation and therefore not allow them to have a driver's license. However, what they forgot in the final rule was giving them the authority to not renew or to downgrade their driver's licenses. So that's the reason for this 3-year delay. It's not any type of laziness or any type of argument that there would not be enough information in the clearinghouse. It's simply a lack of authority given during that final rule. All right, I think we have just one more point on here. What if you just don't do it? You know, Karen, after all this, I think we might have a lot of people that say, you know what, forget it. I'm just, it's gotten too complicated. I don't want to do this
Too
anymore.
much extra work.
I think I'm just going to skip the clearinghouse. You think that'd be a good idea?
No.
Yeah. They list 2 different civil penalty codes. The less of the 2 is $2,500 per offense, and that is specifically at the end of these regulations. They also refer just to 521B, which could be up to $10,000 per offense, depending on the severity of it. So that's certainly not an option. If you're going to continue in the FMCSA world, you're going to have to be compliant with the clearinghouse. And I know there's a lot of information here, but you know, we can just sum it up. You currently do drug and alcohol verifications. For the next 3 years, you're going to have one extra website that you're going to go to. You currently do annual verifications. For the next 3 years, you're going to have one extra you can go to. After 3 years, if everything goes well, it should actually simplify the world. And it certainly will make violations more apparent and will stick around for those violators who think that they can outlast the system. All right. Well, I think let me take a look here, see if we had a couple other questions. So the clearinghouse gives 3 options that CMS or TPA can do for us. Which one should I select? So the clearinghouse gives one option for the TPA to report negative return to duty tests. It gives another one for the TPA to report violations, and it gives a third one for the TPA to perform queries on your behalf. So if you pick corporate medical services or whoever your TPA might be, if they're registered in the clearinghouse, they can do all of those things up to you. Now, that does not, it's not an exclusive contract. The FMCSA is never saying that the TPA is solely responsible for doing those things, unless, Karen, it's back to that point of if you're an owner operator or an employer who also drives, maybe a better way of saying it. In that situation, you are having to designate that TPA. So it is actually the TPA's responsibility to make sure that you as an employer driver also do have the compliance that needs to be done. So feel free to go ahead and check all of us. We'll be happy to work with companies if it's something that you want us to do. I really see our role with most of our clients going forward being more of an educational and assisting role. We will have options on our web portal to be able to do the queries as time goes on, once it starts around January, if that's something that you want to do for us. And we think that it will get simpler as it goes on. Well, Karen, I think that's pretty much everything. Is there anything you thought of as we went through this?
No, I think we covered most of
the questions?
Most of the questions.
Well, we're 2 minutes early, so I guess we can let everybody just enjoy the rest of their lunch break or whatever they're doing during this time. So everyone, we really appreciate it. Karen, I appreciate your help. And just as a reminder, this will be available on our website, a recorded version. If you do have questions that did not get addressed during the webinar or follow-up questions later on, you know what, just email me directly. It's Grady@corporatemedicalservices.com. And again, if you want copies of this presentation in any of the forms that we discussed, feel free to send an email to ch@corporatemedicalservices.com, and we'll get that to you just as quickly as we can. Again, thanks everybody, and have a great day.
Thank you.